What's up, everyone? I know it's been about a week since you've seen me, but that's okay because we're back now. As usual, I am here. As usual, I'm Dr. Tachi. And as usual, I am helping you to be better with your video. This is Be More. Stay tuned.
Close the doors, walk across the corridor. We got something to show you. Media is our repertoire.
Ladies and gentlemen, I am so happy to have a guest with me today. You get another guest. Look how lucky you are. So I'm so lucky to have a great attorney and just an all-around great person who I met at Podcast in March. Incidentally, the last time I was out anywhere in public before the quarantine. So I'm really happy to have somebody that I met at PodFest. This is Merlin Jean-Louis. Merlin, yay!
Hey, Kathy.
Hey.
Thank you for having me. I love your energy. It's so nice.
Thank you. I mean, there's no reason not to be energetic when you have great guests like you on.
Oh,
I
you're
mean,
so kind.
no, people know I don't say things to be kind. I only tell the truth. But anyway, I brought you on today, not just because you're an awesome person, but also because you are an attorney. You're an attorney and you have your own firm, right?
I do. So I have a business entertainment law firm, Jean-Louis Law, based out in New York. I've had it now for 5 years. I basically practice business entertainment law, so contracts, intellectual property, entity formation, and I work in particular areas of law. Particular areas of business as well. I specialize in what I say is non-traditional entertainment. I used to be a dancer myself, and so dance, bloggers, podcasters, influencers.
And see, that's why we click, because I'm a dancer too. So
I remember that when we getting down at the PodFest. I remember that.
We were getting down at PodFest. But one thing that I want to get down into is the fact you mentioned IP. And see, I can say things, but people tend not to believe me. So I want them to hear it from an attorney that deals with intellectual property and deals with the entertainment industry. Is it okay to use, for example, a song, a copyrighted piece of music in a video that you're doing and post it on social media as long as you put, I do not own the rights to this piece of music?
Yeah. So even before I answer that question, I like to tell you what copyright is.
Please let us know what copyright is.
So when it comes to intellectual property, there are 3 types of law. There's patent law, which protects inventions. Then you have trademark law, which protects brands. And then copyright law, which protects creative works. So a work becomes copyrighted so long as 3 requirements are met. Number 1, it has to be considered to be a work of authorship. These are types of works that are listed in the Copyright Act, which is the act that governs copyright law in the United States. It could be a choreographic work. It could be literary work, a book, a novel. It could be a film. Basically, as long as it's a work of authorship, it's copyrightable. Number 2, you have to, the work has to be original, right? You have to use your own creative juices to create the work. And number 3, it has to have the ability to be fixed in something tangible. What does that mean? Right now, we're recording this, right? We're recording this work right now. This is considered to be a work, right? It's creative. What's recording it, right? Your computer or your phone, right? It's tangible because the computer and the phone can be touched. So again, so long as something is a work of authorship, original, and has the ability to be fixed in something tangible, it's automatically copyrighted. As of 1978, it's automatic. So everyone's creating copyrighted material all the time. So, yes, there's not much to it. Before 1978, you had to go through formalities and file paperwork. But after 1978, it's automatic.
Wow.
Yeah.
So we're all creating stuff all the time that's copyrightable.
Yes.
Wow.
Right. But people, when they talk about registering the work in the Copyright Office, that's different,
Okay.
You do that in order to gain more protection. And as of last year, in order to sue for copyright infringement, you had to have actually filed and get a registration for that. But back to your question.
Yes.
So back to your question. So long as something is copyrighted, the person, the author, who's just creator of the work, gets what we call a bundle of exclusive rights. It's like, you can think of it as sticks. So they have the right to reproduce the work. They have the right to perform the work. They have the right to transmit the work. It's their exclusive right. And if anyone else wants to engage in activity, engage in those activities that are protected by their exclusive rights, you have to get permission. And if you don't, it's considered to be copyright infringement. So when someone writes on their post a video that's not theirs, that wasn't created by them, that's copyrightable, and says no copyright infringement intended, it doesn't matter. It's still copyright infringement.
So simply because you write the words, I do not own the rights to this music, or no copyright infringement intended, that doesn't absolve you of responsibility for infringing on somebody else's work.
Right. So long as you do that, so long as you engage in activity, it's infringement.
Right. So it would seem to me that the fact that you're putting those words lets you know that you don't own it.
Yeah. But there's also something actually called fair use. I know a lot of people talk about that.
Yeah, let's talk about fair use. What is that?
Yeah, so fair use is a doctrine. It's a judge-made doctrine that basically is sort of a defense against copyright infringement. It's really complicated. It's like four different factors, like how much of the work you take. What is the purpose of the use you're using for the work? The nature, like there's still 4 different factors that you have to go into, and it's very fact intensive. But ultimately, the key is that it's a defense to copyright infringement. If you're saying fair use, that means to me you're in court giving this as a defense. And so what some people do is they do what's called a preemptive fair use analysis, depending on what type of work they're doing. Like if you're doing film, like lots of films require you to have a fair use analysis before you are able to put it out. But fair use, you can't say fair use. No, that doesn't work that way.
So let me give you a scenario. So say, for example, you have a podcast and you have a podcast about film and you want to use cute, kitschy lines from certain films. Are you allowed to do that? Yeah.
So that's the thing. So technically it could be copyright infringement if you do so. But again, you may want to do a fair use analysis. So it's technically infringement, but also, if you don't want to get the permission, the best thing to do is get permission. Whenever you hear the term license, it basically means permission to do something. And so the best thing to do in order to prevent from being sued is to get permission first from the creator of the work.
And that may mean that you have to pay for it.
Of course, yeah.
Okay, okay. It's not free. We needed to clarify. It may not be free.
Most likely, yes.
Okay, so what about for educational purposes? Is that still the same thing?
So that's one of the things one of the factors for fair use, right? One of the factors for fair use, 4 factors. One of them is the purpose and character of the use. And one of that is one other is being used for educational purposes. Again, it's a balance of factors when you come to determine whether something fair use. So I can't answer that question. If it's just, that could be a factor in your favor, but ultimately maybe you use too much of it. It may be that, like you're making a lot of money off of it. I don't know. Like it depends.
So it's a case-by-case basis.
It really is. For fair use, it's a case-by-case basis. And I know it says it depends. That's a bunch of lordly answer. Like, it depends. But that really is true in fair use.
Well, and I think this is why there's so much confusion, because people want a neat answer to this, and there is no neat answer to it.
There is none. There is none.
So I'm sorry. Yeah, no, especially for fair use. So would you say then the best thing to do is, if you are a creator and you make videos, you're putting them on YouTube, should you then get your own music, have somebody create music for you, or you create it yourself, or you create little things? Should you basically have everything original? Right.
And I think a caveat too, about what I'm giving is not advice. I'm an attorney, but I'm not your attorney. Just have to put that out there. But,
absolutely.
Yeah. But just say in that situation, the best thing to do is you want to hire someone. If you hire someone to do it for you, right?
Okay.
If there is no paper, who owns the intellectual property to what they created? Who owns it? If there's no paper, who owns it? Let's say you have a musician create some work for you. Who owns it? Who owns it if there's no paper? I'm asking you a question. Who owns it?
Oh, you're asking me.
Yeah.
I'm not the attorney. I don't have the big fancy book learning law degree like you.
A lot of people I do is educate people. I like to ask questions too. So if there's no paper, as a musician creates a work for you, who owns the copyright to it?
That's a good question. I would think that if you paid for it to be composed for you, then you own it.
No, but I said there's no paper, right? There's no contract. No paper, because in order to sign copyright, the only way to do so, assign means giving the rights of one person to another.
Okay.
The only way to do for copyright is in paper. So when someone hires someone, a good example of this is when someone hires, an employee, right? Their employee agreement contains clauses that say, hey, anything you create pursuant to your job is owned by us. So if you hire a contractor to do something for you, you'll have to have particular language in there that says, hey, anything you create is assigned to that party.
Yes, no, absolutely. And that's kind of the thing, the catch-22 when it comes to like being a professor or whatever.
Yeah.
Whenever you're doing all these things, if you're doing it under the guise of the university, you have to be careful because they could own all of that stuff. So you just have to be careful.
So, So there's nothing wrong with paying someone for their work, right? You know, and so and the other side too, the other side can value, okay, if I'm not just giving you the work itself. Like I see this a lot in designs. Like I create a logo for you. You pay me for the logo. But if you don't pay me for the IP rights to the logo, that's a problem. For example, this, the logo for the Rolling Stones, the tongue with the sticking out.
Yeah.
Initially, the creator of it did not assign the IP rights. And so like, I think about 10 years later, after they did so, Rolling Stones came back to them and said, hey, can you assign us the IP rights? Can you give us the rights? And of course, at that time, the person could ask for beaucoup money because like the mark is very valuable. So it's best to just do it preemptively, like pay them for not just their work, but pay them for the rights as well.
Interesting. Great advice, though. You are not giving advice
as
an attorney. You are not giving advice. It is great information.
Yes.
Let's say that. Thank you. This is great information, and you are such a great person. Thank you. Thank you so much. If anybody wanted to contact you because they do want to make you their attorney, how would they do that?
So there are several ways. You go to my website, jllaw.net. I actually have a free business checklist, the things you can consider when you're operating a business. If you're making money, you're doing anything that could put you in liability and like in danger of being sued, you're engaging in business. And so it's just a checklist to help you. I have a very unique name. So if you Google me, Merlin Jean-Louis, MERLYNE JEAN-LOUIS. I'm Wizard Lawyer on Instagram as well as Jean-Louis Law on Instagram. But you will find me if you Google me. You will find me.
You will find her. Don't worry. Don't worry. Thank you so much,
Thanks,
Merlin.
Tashi, for having me. I appreciate it.
Cheers.
Bye.
Wow. So hopefully you all got a lot out of this session. Thank you again to Merlin Jean-Louis, who is a fantastic person and also a fabulous attorney, for giving us the insight on IP and copyright. She even broke down the definition of copyright. Therefore, you all will need to level up and be smarter, better, wiser, stronger, wealthier, just more. So I'm hoping that this session helped you to be more. See you next time. Cheers.
Settling our knowledge and conversations, don't make them yours.